I'm going to go ahead and call to order the monthly board meeting of the Lost Pines Groundwater Conservation District on Wednesday, January 20th, 2021 at 7:10 p.m. I welcome everyone to our meeting this evening. I see we have a large group in attendance listening to us, so we greatly appreciate your interest in the affairs of the district. The first item for action is item number 3. Pursuant to Board Rule 21A, the board will conduct its annual election for president, vice president, and secretary treasurer for board action. So I open this item to the board.
Mr. Chairman,
Yes, sir.
I think you need to ask the secretary, treasurer, and the vice president if they want to continue with their office.
Okay. Vice President, Billy, do you want to continue in that role as vice president?
No, sir. I think it's time for me to give it up. I think you need a break.
Okay. All right.
Thank you for taking care of me. I always appreciated being the vice president. It's something that I will enjoy the rest of my life, but it's time for me to step down. And thank all y'all.
Okay. Secretary Treasurer, Mr. Semaine.
Yeah, I'll stay another year, Mr. Chairman, if it be the pleasure of the board. I just had a few months, and I'm just trying to find out, learn what to do.
Okay. In regards to the president, I will continue for another year if it's the desire of the board. The board feels there needs to be a change. I certainly can understand that too. So I will serve, but I will leave it up to the board as to your wishes.
This is Phil Cook. I'd like to nominate Mike to continue as president and Mike Semang to continue as secretary treasurer.
Is there a second?
I'll second that.
I'll second it.
Okay, we have a motion and a second to reappoint myself, Mike Talbot, as president and Mike Semaine as secretary treasurer. Any questions from the board? Any opposition? Any noes? Motion passes. So we still need to fill the position of vice president. And again, I will open up for this to the floor. And
Cheryl, would you be willing to accept a nomination for vice president? Cheryl Smith?
Cheryl, you still with us?
Yeah. Yes, I would accept only if there's not someone else that would really wants to do the job.
Okay.
I think it is appropriate that somebody from Lake County, I think that would be great.
Yes, I do too.
I move that we close the nominations.
Okay.
I'll second that.
Okay. The nominations have been closed, and it's been made motion for electing or appointing Cheryl Smith as our vice president of the board. Any opposition? Any noes?
No.
One no.
No.
Okay. One no.
Correct.
The motion passes with one vote in opposition. Cheryl, you are the new vice president. Okay. This next
Thank you.
item, yes, I want to say try and stay on track here with the agenda. I appreciate the confidence the board has in reappointing me as president. I consider it a great honor, and will try to my best of my ability to meet the needs of the district and the board.
Mr. Chairman, I hope you still feel that way during the year.
I wouldn't if I gave it a long thought between Christmas and New Year's. But as I said, if the board was willing, I had decided I would stay on another year. So thank you, Mike. And I'm a big boy, so if I have something I'm doing you're not happy with, I can't correct it unless you tell me. So always open to suggestions. With that, I'll move down to public comments. This is an opportunity for anyone who may be listening in to our meeting this evening to address the board on anything they'd like to bring to the attention of the board that is not on the agenda for action. Anyone wish to address the board under public comments?
This is
Yes,
Kermit
President
Eaton,
Talbot,
I would.
Andy Weir.
Andy Weir has asked. Andy, you have three minutes, so take it away.
Okay, I'm also going to share my screen during this time. President Talbot and board members, my name's Andy Weir. I'm a resident of Bastrop County. I have a registered well in the Simsboro formation of the aquifer. I'm a director with Simsboro Aquifer Water Defense Fund, or SAWDEF, and we work in Milam, Burleson, Lee, and Bastrop counties with landowners, GCDs, the government, and business to protect the Carrizo-Wilcox. Our mission is very similar to the district, is the one you see here on the screen. We weren't created by an act of legislature, but we're out to protect the water supply for residents in Bastrop and Lee counties. And tonight I'm asking you to renew your commitment as a board, as a district, to protect the water supplies for residents in northern Lee County. SAWDEF has been contacted, here we go, by 15 residents so far in the area who have domestic wells in the Carrizo that have been sucking air. They've had to spend $1,000 to sometimes 3 times that amount to lower the pumps in their wells. They've experienced anywhere from 50 to 100 feet of drawdown. In just 1 year since Vista Ridge has started pumping in the Carrizo. So why is this important? I want to tell you, I looked at the appraisal district, and after ag exemptions, these 15 properties total $2.6 million in the Lee County appraisal district. Their market value is over $6 million. That's what residents have invested in their water supply, and your duty is to protect that water supply. There's an estimated 94 Carrizo wells in Lee County, including the municipal wells in Lexington and Giddings. So the county appraisal value on all of those properties is over 200 million and maybe 600 million market value. What is those properties going to be worth if and when there's no water? So in December, SAWDEF started getting contacted by these residents. And we realized, we looked at the Post Oak Savannah in September, they had a slide at their meeting, this slide that you see here, that showed on their prediction of the GAM of the drawdown in the Carrizo, they were able to predict it very accurately. So I asked for those numbers, SAWDEF asked for those numbers, and Post Oak would not provide them for fear they'd get into a pickle with Vista Ridge. So I came to Jim Totten to get those numbers, and he provided those slides. And so here you see the transmission as those things deepen. You can see that there's more to come. So we have shared these slides with residents and with well drillers, and we're going to have an article in the paper to publish this so that people can plan how far to put their pump down. This is the kind of engagement I would like to see the district take, this type of outreach to the residents of Bastrop and Lee counties. You are the board. You set policy. You also set tone. You set the
Got about 15
attitude for the
seconds.
district. I would like you to set the tone that you are committed to protecting the water supply for residents in Bastrop and Lee counties. Thank you.
Thank you, Mr. Weir. Okay. Is there anyone else wish to address the board at this time? One more time.
Yeah,
Mr. Kermit
I
Heaton.
would.
Mr. Kermit,
Yeah, Kermit Heaton, I was having trouble with my computer.
No
I'm
problem.
not overly computer literate.
I understand. Don't feel bad. Go ahead.
Okay, my comment's real simple. I'd like for someone at Lost Pines Groundwater Conservation District to comment on the impacted wells within the Lost Pines District in Lee County since the recent commencement of pumping in the Vista Ridge wells in the adjacent Post Oak Savannah Conservation District. Can somebody provide a comment or position or an idea of what you think about that situation? That's the end of my comment.
I think the only comment I can make, sir, it's not on the agenda for discussion tonight, but I can say at the December meeting, we created a well monitoring committee, and I know that they've met once, and their initial focus was to look at Lee County and what was going on there. And if you want some further information on what the committee did at their meeting, you can contact Mr. Totten at the district, and he can get you additional information, okay?
I will do that. Thank you, sir.
Anyone else?
President Talbot,
Yes.
this is Linda Curtis. I'm sorry, I didn't realize I had to unmute. I have a comment.
Go ahead.
Okay, thank you, sir. I'm going to read a brief comment from Michelle Gangnes, who cannot get on this call for some reason. There's issues with phone connectivity in Blue. So hers is very brief and mine is even briefer. So Michelle Gangnes, she says here she's a landowner, everybody knows that, and is dependent on aqua water in her property in Blue in Lee County. She says, I just wanted to assure you of the sincerity of the Simsboro Aquifer Water Defense Fund's interest in helping you achieve your mission to protect the water supply of Lee and Bastrop counties. Mr. Weir's summary to you tonight about where we are as a community and where our groundwater resources may be going says it better than I could, so I will simply adopt his remarks both for SAWDEF and for another local conservation group, Neighbors for Neighbors, whom I also serve on as a board member. Neighbors for Neighbors has been around for over 20 years, working in this community to protect natural resources. We played a large role in getting the San Antonio water system to back off the unsustainable project SAWS wanted to do with Alcoa. SAWDEF was founded by NFN, Neighbors for Neighbors veterans, and now has the benefit of energetic, technologically gifted youngsters like Mr. Weir. We are in contact with hundreds of landowners in several counties who follow our efforts to protect aquifers and landowner rights to their groundwater. In concert with Neighbors for Neighbors and the League of Independent Voters, one of whose core issues is groundwater and aquifer protection, our combined outreach is very extensive. If you think folks aren't paying attention to what happens to their water, think again. Those hundreds of folks who appeared at the preliminary hearing for LCRA a couple of years ago weren't there by accident and haven't gone away. And you can be certain they identify this district and neighboring groundwater districts with whatever good and whatever bad happens to their property rights and their lifeblood water. My comment is very brief. I'm Linda Curtis with the League of Independent Voters. We were in court yesterday in San Antonio with San Antonio Water System in Travis County. And it's too complicated to explain, but they are really on a mission to stop the citizens of San Antonio from voting to get even just an audit of Vista Ridge. And let me tell you, we got a tiger by the toe and we're not letting go. So I got one word for what I'm asking you to do tonight. That word is moratorium. Moratorium on new permits. Thank you so much.
You bet. Thank you, Linda. Is there anyone else that is, whoops, I don't know what happened. I lost everything now here. Hold on. Oh, boy. Oh, just a minute. I'm sorry. I don't know what happened here. Okay. I'm sorry. I don't know what happened. It just went blank. But is there anyone else that's had a problem getting on that would like to address the board? Okay. We appreciate those comments and taking time to share those with us. And we will certainly take them under review, and appreciate you taking time to share that with us here this evening. We will now move to item number 5, review and approval of the minutes of the December 16th, 2020 regular board meeting. The minutes were in your packet prior to the meeting this evening. And if the directors are comfortable with the minutes, I will entertain a motion to approve.
President
Chairman.
Talbot, I'm sorry to interrupt, but I believe we had someone sign up to make a comment on the minutes. I believe it was Mr. Weir.
Okay. I didn't get that, so I'm sorry.
Oh, thank you. I had sent a follow-up email. That was just a copy and paste error on my part. I'm
Okay.
not speaking.
Okay, sorry for the interruption. Just wanted to cover that.
Motion to approve the minutes.
Okay.
I second the motion, Carl Steinbach.
Okay.
David Fleming is the motion.
Motion made by David Fleming and seconded by Carl Steinbach to approve the meeting minutes of the December 16th, 2020 regular board meeting. Is there anyone in opposition, opposed to the approval? The minutes are approved. Item number 6 is consideration and possible action on the 2021 district calendar. Calendar was in your packet. Jim, do you want to make any comments regarding the calendar?
No, sir. At this point in time, we tried to do this back in December and forgot to include the calendar. We just wanted to get the dates out to y'all so you could have them and see what we're looking at for the year coming up.
Okay. All right. I will entertain a motion. We accept the district calendar for 2021.
So moved.
Okay. Do I hear a second?
Herbert Cook, second.
Larry Shotty, I'll second that.
Okay. Motion was made by Board Member Fleming and seconded by Board Member Shotty to approve the district calendar. Is there anyone in opposition or has any questions? The district calendar is approved. Okay. Item number 7, consideration of the financial report for the period of December 1st through December 31st, 2020. The financials were in your packet. Mr. Totten, is there anything you would like to add to those minutes? I mean, any comments regarding the financials?
The only thing I will mention is that the operating fund did drift higher than we normally keep it. We try and keep it around the 250, 300,000 mark. So it's drifted up to about 400,000. We'll be transferring some of those funds over to tax pool to get that operating fund balance back into our normal range. But other than that, the year pretty much wrapped up as we expected in December. I don't have a whole lot to report. It's kind of the easiest one we do. It's, everything's either spent or unspent. But I'd be happy to address any questions from the board.
Okay. Let me get a motion and then we'll open up for questions. I will entertain a motion that we acknowledge the acceptance of the financial report for the period of December 1st through December 31st, 2020. Do I hear a motion to that effect?
Carl Steinbach,
Yes,
so
it's
moved.
Larry Shoddy, I'll second it.
We have a motion and a second to acknowledge the acceptance of the financial report for the month of December. Does the board have any questions of Mr. Totten regarding those financials? Only comment I'll make, I think the district ended up in a very favorable financial position at the end of the year. So I appreciate the staff's work and taking oversight of our funds. With that being said, anyone opposed to acknowledge of acceptance? We will acknowledge acceptance of the financial report. Item number 9, discussion of and possible action. Oops, I'm sorry, I missed one. Consideration of and possible action on district surety bonds for the directors and any other district office employees. Jim?
I guess, so this, we were contacted by the company that handles the surety bonds for directors back, I guess in late December. And they were asking us to update our list of directors and get, basically renew all the surety bonds for the directors. And so Peggy sent out to the board members the necessary paperwork that we need to get back to basically to refile and get the surety bonds reissued for the district. I don't recall us having to have a board action on this in the past. However, I believe this time they were asking for, something from the board, acknowledging that, the board approves the reissuance of the surety bonds. Natasha might be able to better state the issue with that.
Sure. Am I off of mute?
Yes.
Yeah, Chapter 36 does allow for the district to require the directors to execute this bond for $10,000, and the board, it's subject to board approval, and the actual disbursement of funds would be paid for by the district.
Okay. So I will entertain a motion that we approve the issuance of surety bonds for the directors and any other officers and employees of the district. Do I hear a motion to that effect?
So moved.
I got a motion. Do I hear from Board Member Fleming? Do I hear a second?
Herbert Cook, second.
Mr. Cook, seconded. Any questions? Anyone in opposition to the this item? Item number 8 is approved. Item number 9, discussion of and possible action on the formation and appointment of members to a legislative committee. That falls under the purview of the president, and to respond to the request of Mr. Ellis and trying to balance the needs of the board, who historically has expressed interest in this matter. I'm going to appoint the officers of the district, which would be myself, the vice president, and the secretary treasurer, along with Mr. Totten and our board attorney, Natasha Martin, as the legislative committee to coordinate between Mr. Ellis and making sure that the board stays apprised, and in no manner is that inferring that we will not have Mr. Ellis present from time to time to give the board a full update. As I did with the monitoring committee, I will be putting together over the next couple of weeks an order outlining the duties and responsibilities of the legislative committee, and get that in place. Okay. I know you all are very interested, and I think with all the officers present, we've got a good balance, and we'll make sure that we get the important items quickly to the board as they are brought to our attention. Okay. With that, I will move on to item number 10. This is consideration of and possible action regarding the request of Recharge Water LP for reissuance of operating and transporting permits to reflect a March 9th, 2023 expiration date as a result of tolling of the permits from the judicial action and renewal of the transport permits authorized under District Wells number 585512, 58555513, 58555514, 58555216, 58555217, 5855323, 5857809, 58555218, 5847602, 5847303, 5847304, 5848212, 5848121, and 5848122 from the Simsboro Aquifer located in Bastrop and Lee counties, which the district has processed as a request for an amendment of the dates of the expiration of the operating permit pursuant to Rule 7.2C and request renewal of the transport permit pursuant to Rule 6.6 recharge. At this point, I would like to ask the applicant if they would like to address the board on this matter. And then we'll take a staff report.
President Talbot, I'll be recusing myself from this item.
Okay, David, thank you. Anybody else will be recusing?
President Talbot, this is Phil Cook. I won't participate in any manner in the proceedings on this.
Okay. Mr. Cook has stepped down. Anybody else? Okay. I saw Mr. Terrell was on.
I'm on.
Okay.
President Talbot. You ready for me to talk?
Yes, sir. I'm going to turn it over to you now, sir.
All right. I'll try to be brief. I know this has been in front of the board on the previous two meetings and has been discussed extensively. So I'm gonna keep my remarks short and tie it to the legislative language that was passed during the last legislative session. And in that last legislative session, the legislature mandated the extension of the term of transport permits to match operating permits. This is in Texas Water Code 36.122, and I'm going to read the operative language. It's simple. It's one of those things where law can sometimes get complicated, but sometimes the language is plain and direct, and this is an example of it. Here's the language. A district shall extend, so it's mandatory, a district shall extend a term under subsection I2 or J on or before its expiration in the manner prescribed by section 36.1145. And then the subpart says to a term that is not shorter than the term of an operating permit for the production of water to be transferred that is in effect at the time of the extension. Now, the simple import of that language, and it's talking about transport permits, and it's in the section on transport permits. The simple effect of that language is the district shall extend a transport permit to at least the term of the operating permit. And here, there is no question that Recharge had a 3-year transport permit and a 5-year production permit. That statute automatically extended the term of the transport permit to match the term at a minimum of the operating permit. So in other words, the 3-year permit became a 5-year permit. The district has also adopted a rule that's mandatory, reflecting that legislative change. That's Lost Pines Rule 6.5A. And the district has already extended the term of another permittee's transport permit. So that precedent already exists, and this isn't a new issue. The district must follow its law and its precedent to extend Recharge's transport permit to match the term of its operating permit. This has been tabled twice when it's mandatory and should have been done automatically. We all have to follow the law. Recharge has to follow the law, and the district has to follow the law. And if the district doesn't follow the law, and it's going to leave Recharge with no recourse but to have a judge order the district to follow the law and extend the term of the transport permit to match the operating permit. Nobody wants that, or well, I should say this. Recharge doesn't want that. I don't think that the district wants that. I know that there are some people that are hoping that Recharge's project fails, that want to see Recharge in the district get into a fight. I don't think that that benefits the district, and I certainly hope that the district does not get drawn into that dispute. Director Cook, who is not participating in this, did participate earlier and made arguments about it. And, and it's important for the district to remember that when the district granted Recharge's permits after a very long hearing process that lasted more than 10 years, Director Cook who was not a director at the time, is a member of environmental stewardship, and environmental stewardship sued the district to invalidate those permits. And in the district court did in fact invalidate those permits for over 400 days, 432 days to be precise. And when we mediated the case, while the case was up on appeal, Director Cook was the representative for environmental stewardship in that case where environmental stewardship had sued the district. I say that as background because I think it's important to understand that there's history and there are agendas. I'm not saying that the agendas aren't legitimate. That's what this process can be for making public policy decisions. And as a, special interest groups like environmental stewardship have every right to make their case. But in that case, they lost. They won in district court, but they ultimately lost on appeal. And during that time, Recharge, which had been granted a 3-year transport permit and a 5-year operating permit, did not have its permit for over 400 days. I think it's 432 to be precise. Recharge could not pump water. It couldn't transport water out of the district, and it wasn't paying district fees. And the reason is Recharge did not have the benefit of its permit as a matter of law. What I ask this district to do is to acknowledge the legislature's adoption of 36122 with the mandatory extension of the transport permit to match Recharge's operating permit that is unquestionably in effect today. I don't have any further comments right now. I'm happy to answer any questions that the district's board or anyone else, the district's lawyer might have, but those are my comments, which I've tried to keep brief.
Thank you, Mr. Carroll. I will just recognize the board or the staff regarding if you have any questions for Mr. Terrell. Natasha or Jim, do you want to have a comment or anything to say?
President Talbot, as you know, we're posted for
Executive session
on this item. I mean, I will say that, close reading of the rules, I would advise that Recharge's application does meet the standard for renewal of the transport permit. And then upon renewal, there's an automatic syncing up of the expiration dates. We can talk about that further, and there's some other nuances, but
okay.
We should go into executive session at this time.
Okay. Well, at this time,
unless there's members of the public that would
What's that now?
I think there may be members of the public that may want to speak, and I imagine after that, the applicant may.
I didn't receive anything of anybody wanting to address this item.
I believe we did get some registrations with Peggy earlier today. Is that right, Peggy?
Yes, that's correct. And I emailed those out.
Okay, it must have been, okay. All right, let me see if I can pull them up real quick.
Mike, you may just want to ask if there's anybody that wishing to speak on this item.
Is there anyone that would like to address the board on this item?
Yes, Mr. President, this is Andy Weir.
Okay. Go ahead, Mr. Weir.
President Talbert, board members, I believe you received a memo from me concerning part of these renewal of these permits. I focused on the transport permits. As Mr. Terrell stated, we do need to follow the law. And I was present when this law was conceived, debated, and I wasn't present for the signing, but I was there for all the discussion of it. It's focused on the two 30-year permits that are enclosed in the preceding section, that I-2 and J that are referred to in the law. Those both have to do with 30-year permits that have infrastructure. They become 30-year when you have the infrastructure in place. The permit for 3 years, as Mr. Terrell said, they have a 3-year transport permit. He repeated that 3 times this evening. That section is not included in the law HB 1066. It was specifically left out. I was present at the Senate hearing on this bill, and I was personally invited by Senator Perry to meet with his committee staff and talk about possible amendment to this bill. Because I'm a citizen activist and not a registered lobbyist, they felt that I was confused, and they repeatedly told me that this only represented 30-year permits with infrastructure. So I think I can speak something to the legislative intent of this bill. So as I pointed out in my memo, it's unfortunate, but these transport permits expired on September 21st, 2019. There was no application made to renew them at that time. You can't apply the tolling because of the the 432 days, because you're voting on that later tonight. So those didn't apply. There's no tolling. There was no application, and it doesn't qualify for HB 1066 for the change in the water code. So unfortunately, they expired on 9/21/2019. Now, as regards tolling, I've reviewed the water code. I've reviewed precedent in water and all of your rules for the district. And as Mr. Terrell stated, and as Ms. Martin stated, we have to follow the rules. So scrutinize your rules. There's nothing that empowers you and allows you to extend the expiration date of these operating permits because of tolling due to judicial review. So that's the comments that you would get from me in my memo. Thank you very much.
Thank you. Is there anyone else wishing to address the board on item number 10? Peggy, did you receive anything from anyone else?
Let's see, just Michelle was the only other one I received anything from on that.
Okay, that's what I found, okay.
She can't get on the line.
Pardon?
She can't get on the line, I'm sorry.
Okay. Well, okay, then I guess we will, is there?
President Talbot?
Yes.
Do you mind if I respond to those comments for Mr. Weir?
Sure.
If you're going to let him do that, please let Mr. Weir respond. I'm tired of of this, what Terrell does at other groundwater districts, he's always got a comment. Please let others respond who are on the opposite side. Thank you.
I'm going to
Don't know
limit,
who was talking. I'm sorry, President Talbot, go ahead.
I will limit your comments to 3 minutes and then go forward.
Okay,
Okay.
and the ordinary process is always applicant goes first and gets a chance to rebut comments that were made. First, Mr. Weir is dead wrong that the transport permit extension statute doesn't apply to anything but 30-year permits. Look in 36122. You will not find one single word in that statute, which of course he didn't cite that. He didn't give you any words. There is not one single word in that statute that in any way, shape, manner, or form limits it to only 30-year transport permits. And that would be a ludicrous policy also. Why would you only extend 30-year transport permits and not extend, say, a 3-year permit to match the term of a 5-year permit? That makes absolutely no sense, and the statute does not say that. That statute is mandatory. It went into effect on September 1st of 2019. Recharge had both transport and production operating permits at that time, and that extension happened automatically as a matter of law once that law went into effect on September 1st of 2019. Mr. Weir is also wrong about what he has referred to as tolling. Tolling is a term that does not maybe fit perfectly for this situation. What does fit perfectly is describing what happened. I touched on it earlier. Recharge, after a very long permitting process, was granted permits for 3 years and 5 years, 3 for transport, 5 for production. Recharge did not get the benefit of those permits because environmental stewardship sued Lost Pines Groundwater District and was able to invalidate those permits for well over a year. No amount of pretending can change the fact that Recharge did not have a permit for 432 days of its 3 and 5 year permit terms. That's obvious because, again, Recharge couldn't produce water, couldn't transport water, wasn't paying fees to the district as well. The natural consequence of this is that the permit term, Recharge gets the full benefit of the 3 years for transport and 5 years for the operating permit. The district's lawyer has confirmed that in writing, and the general manager has confirmed it as well. That's all a matter of record, and that has happened without regard to Mr. Weir's theories about how the district should implement its law and what the Court of Appeals did when it reversed the district court's judgment. I ask once again that the district follow the legislature's mandate that transport permits be extended to match the term of production permits. And I don't have any further comments unless any of the directors have any questions.
I will ask, does any of the directors have a question of Mr. Terrell before we move on? Any questions from the board? Okay.
President Talbot, thank you for allowing me to speak.
You bet, no problem. Mr. Weir, if you want to make a comment, you may, but you're going to be held to the 3-minute rule, and be concise in your comments before the board, please.
Mr. President, if I might interject here, I think we're on a fine line of the Open Meetings Act, as it does not allow an opportunity for deliberation or debate with the public. And Mr. Weir has had an opportunity to submit written comments. He's made oral comments. So I believe just it's time to go into executive session.
Okay. Okay, just a minute. Okay, it is.
Excuse me,
We are
President
posted for executive session for this item. So at 7:54 p.m., the board will adjourn into executive session pursuant to the Texas Government Code, Section 551071, so that the board may seek the advice of its attorney regarding pending or contemplated litigation, included but not limited to the following. Item 10 on the agenda, as stated when we opened the item up, of consultation with attorney regarding the above posted recharge request.
President Talbot,
Yes.
I'm so sorry, but the problem is that Michelle can't get on the line. Mr. Terrell he insults the other side. And because we're in these COVID rulings where we can't get people on the line, I really want to at least lodge an objection to even letting Andy respond. And this is just really just not right.
Well, I have to confer with the board attorney. When you're in a public meeting and the board is conducting business, we're not here for an open debate. We're here for a board decision, and that's what we need to do. I think I provided ample time for public comments, and written comments were received and disseminated to the board. So I think everyone's view, both pro and con, have been made very clear to the board on this item. And with that, we're adjourning to executive session. David, okay.
Could you do a roll call, please, of the directors?
Okay, only the ones that are going to vote on this. Ms. Rogers, are you back yet?
I'm back.
Okay. Mr. Steinbach, are you back?
He's back in, but he took I think a quick break.
Okay. Mr.
There he is.
Semaine? Mr. Semaine?
Yes, sir, I'm here.
Okay. Mr. Herbert Cook?
Yes, sir, I'm here.
Good. Mr. Larry Shoddy? Larry?
Yes, I'm here.
Okay, thank you. Ms. Cheryl Smith?
Yes.
Okay. And Mr. Billy Sherrill? Billy?
He's on mute. Billy, it's the bottom left corner. There's a little speaker button. You push that, that'll take you off of mute.
Okay.
He's here. I'm gonna ask him to unmute.
Okay. Then I think my roll call shows that those that can vote are back in from executive session. So I'll reconvene us back into regular session at 8:32 p.m. And we have had consultation with legal counsel after hearing the discussion prior to going into executive session. I am going to open the floor for a motion regarding the request of recharge water for the reissuance of an operating and transporting permit. As stated on the agenda. And so I'm opening it up for a motion.
Mr. Chairman, Semang here. At the last meeting, I made the motion that the transport permit be granted. That motion died as for lack of a second. I still think that the permit should be granted to sync it up with the operating permit. And so I would move that the transport permit be granted to sync up with the operating permit as required by the statute. I think that date is January 1 of, well, it'd be 22 because we're in 21 now.
Yep, 2022. That's correct, Mike. Okay, we have a motion from Mr. Semaine that we authorize the extension of the transporting permit to sync up with the operating permit with an effective date of expiration of January 1st, 2022. Is there a second to that motion?
Herbert Cook, second.
Okay. I have a motion and a second to grant to Recharge a date of their transporting permit in accordance with Rule 6.2 to sync up with the date of the operating permit, which will be January 1st, 2022. Is there any questions before we vote?
I have a question.
Who's
Mike?
Kay? Okay, go ahead.
Yeah. You said Rule 6.2. Did you mean Rule 6.6?
Yes, I'm sorry. Got too many papers in front of me. I apologize.
No, no.
Thank you for the correction.
You bet.
I think because we have to have 6 votes to approve this, I'm going to have to do a roll call of the vote unless you don't have any more questions before you vote. If you're not ready to vote, tell me. But if you are, I'm going to do a roll call. Okay. Kay Rogers.
Yes.
Okay. Carl Steinbach. Carl? Okay, I'll come back to Carl. Mr. Semaine?
Yes.
Okay. Mr. Herbert Cook?
Yes, sir.
Mr. Larry Shoddy? Larry? Still with us?
He's on mute.
Okay. Miss Cheryl Smith?
Yes.
Okay. Mr. Burley Sherrill?
Yes.
Okay. Did Mr. Steinbach come back on?
He's listed as a participant, but I'm not able to unmute him.
Okay, how about Mr.
There he is.
Yes.
Yes, okay. Thank you, Carl. And Larry? Mr. Shoddy?
He's here. He just unmuted and muted himself again. Oh, Larry, there we go.
Okay.
Are you in favor of the motion, Larry?
Yes, I am.
Okay. There is 1, 2, 3, 4, 5, 6, 7 votes in affirmative for this to be extended for the transport permit to sync up with the operating permit. The motion carries because it has more than 6 votes. So that will take care of item 10 for this evening. So we will move on with the agenda. Since item 11 and 12 are covering the same subject, I'm going to bring both of them up on the table and let the applicants make their presentation. So we only have to go into executive session one time, if that's acceptable to the board. Okay. So I'm going to bring up item number 11, consideration of and possible action regarding the request of Gatehouse Water LLC to renew transport permits for District Wells 5933122, 5933123, 5933217, 5933409, 5933410, 5933411, 5933412, 5933413, 5933504, and 5933505 from the Simsboro Aquifer located in Lee County, which the district has processed as a request for renewal of a trans permit pursuant to Rule 6.6 Gatehouse request. Item number 12 is consideration of and possible action regarding the request of Gatehouse Water LLC for no increase amendment to special condition number 8 of the operating permit for the district wells 5933122, 5933123, 5933217, 5933409, 5933410, 5933411, 5933412, 5933413, 5933504, and 5933505 from the Simsboro Aquifer located in Lee County Gatehouse permits, and a request to modify the 2016 monetary walling agreement applicable to the Gatehouse permits to address certain district monitoring network issues raised by the district board, which the district has processed pursuant to Rule 7.2 and 15.4. Is the applicant present to speak to the board on this?
Good evening, Mr. Talbot. This is Ed McCarthy, attorney for Gatehouse Water LLC. Also on the meeting, but I'll be speaking at least initially unless there are questions of the board that I need to defer to one of the co-managers of the Gatehouse. I'll be speaking and addressing the issues. But with me is Mr. Matt Rose, the president, one of the co-managers, Mr. Dean Blaine, and Mr. Doug Fike, also co-managers for the project. Our engineer, Mr. Coleman, is on the line also. And if you're ready, I'll go ahead and start.
You start, sir, yes.
Okay. Thank you, Mr. Talbot and board members. I appreciate the opportunity to be here for Gatehouse and to address these two agenda items, as well as to provide you with updates on the progress Gatehouse has made since they acquired the project in January of last year to move forward and implement the permits, including the monitor well requirements, and provide a wholesale water supply on a regional basis to meet needs here in Central Texas and the counties that the district has authorized. With respect to the transport permits, I believe that I'd like to second the statements related to the law that Mr. Terrell made to you. Under the amendments made by House Bill 1066, the renewal of the transport permits is also supposed to be an automatic factor. The question is if infrastructure, commencement of construction on the conveyancing system, not the actual installation of infrastructure, has begun, then it's supposed to be an extension of the transport permits for a 30-year period. At a minimum, even if there hasn't been any commencement of construction, there's a default provision in the statute that provides that that would be at least 3 years, or if there's an operating permit of a different length, it could sync up with the operating permit term. Excuse me. And so those are the parameters of the statute. One of the updates I wanted to provide to you, and at the last meeting I presented comments that I believe Ms. Martin concurred with, that we initiated commencement of construction years ago, actually through the predecessor entitled 4-Star USA Real Estate, when they installed the 3 TCEQ approved public water supply wells, as well as the existing monitor well, secured public water supply status for the project overall, and moved forward at that point. Since then, in addition to those factors, we've done substantial engineering work since Gatehouse acquired it. All of those reports and information and data are on file with the district. We included them in our timely filed application for renewal. Since then, because there was concern about not enough dirt being turned with respect to the project, we also have coordinated with landowners. And one of our landowners, Mr. Gary Brown, who himself owns earth moving equipment, had commenced and has commenced clearing of right-of-way in substantial areas of his property, going from well number 5, one of the Gatehouse existing wells, also the fact where our existing monitor well exists, to clear the right-of-way for the installation of pipe from well 5 to his property line. Today, I was able to secure and deliver to the district's council and general manager an affidavit from one of my Gatehouse co-managers, Mr. Doug Pike, who's been on Mr. Brown's property and toured it with Mr. Brown and taken photographs of the work that's been done. And those were included in the affidavit. Mr. Pike actually took the photographs and is able to corroborate and support those photographs. I also provided what's known as an unsworn declaration, which under Texas law, properly prepared, substitutes for a sworn affidavit from the landowner lessor himself, Mr. Gary Brown. In that unsworn declaration, and we used an unsworn declaration because Mr. Brown was traveling and unable to find an available notary, so we used the unsworn declaration methodology. But his declaration includes statements that corroborate what I just told you about the effort that he has made to clear substantial acreage on his property from well 5 headed towards the property line for the purpose of the Gatehouse pipeline. Has verified the pictures which Mr. Fike took, including pictures of his bulldozer equipment, so you can see the heavy equipment. And again, he owned it and knows how to operate it and uses it on his property. So both of those documents are there, and I believe they substantiate and fully support Gatehouse's request for the extension of its transport permit. And I believe under the law that supports actually the extension of the transport permit for a 30-year term. With respect to the operating permits and the application that I filed with the district earlier this month to amend the permit for a no volume increase, there's several background facts I want to provide you. As you're aware from our presentation at prior meetings, including the last December board meeting, Gatehouse, since acquiring the project in January of 2020, has diligently and vigilantly pursued contract customers. We've been hampered by a variety of matters, excuse me, including COVID pandemic, but that hasn't deterred the Gatehouse folks from working to move the project forward. Mr. Jim, I'm sorry. I thought there was a question. I apologize. Mr. Jim Briggs, who's the former utility director of City of Georgetown, participated at the meeting last month and provided the district with information about his work with Brazos River Authority and the cities of Round Rock and Georgetown, collectively look at developing regional water supplies for those entities, and that they were talking directly with the Gatehouse folks. We had submitted a response to a request for a proposal from them. They had requested supplemental information. The deadline for filing that was December 16th, the same day as your board meeting. We did file that. Mr. Briggs verified it and said that they were reviewing all of that and would be considering the matter this month, but then probably taking formal action in the February timeframe, and verified that. In addition to those three entities, Gatehouse has received inquiries from other entities and pursued discussions with them. One of them is the Central Texas Water Supply Corporation, which is a nonprofit water utility created in the state of Texas, formerly under the Nonprofit Water Supply Corporation statutes and currently under Chapter 67 of the Texas Water Code. They operate in 8 counties in Central Texas, north of Austin, including Williamson County, and they were interested in additional water supplies for service that they could do in Williamson County at least immediately, because that's the most northern county which our permit authorizes beneficial use of our water at this time. We pursued diligently on both party sides a contract with them for a long-term water supply contract. The COVID bug bit us there also. I think more than half the directors came down with COVID, and there was problems scheduling meetings, and full deliberation and consideration of the points of the contract weren't able to be brought to a conclusion. But they were very interested in the water and wanted to tie the water up so that they could study the opportunities and work it into their inventory on a more long-term basis. We apprised them of the discussions with BRA, Round Rock, and Georgetown, as we also apprised Mr. Briggs that we were talking to Central Texas Water Supply, so that everybody knew what we were doing, and it was all on the table. And there was an interest in the ability to have a contract for water from our project to actually be utilized by all of these 4 entities, and for them to work cooperatively on a regional style type project. We ended up, and today I was able to present to Jim Totten and Natasha Martin a contract for the sale of 12,000 acre feet of water to the Central Texas Water Supply Corporation for the year 2021. That contract has been fully paid up. That contract requires full compliance with the terms of the permit, including the monitor well agreement between Gatehouse and the district. And so we're going to work to, one, facilitate the implementation of the monitor well agreement, and continue working with Central Texas Water Supply for the delivery of that water. And as part of the contract, we also granted them, as I said, it was for the year 2021, we contracted for, and they paid consideration for, an option agreement to negotiate terms of a long-term 40-year contract for the water supply. Again, keeping in mind the discussions ongoing with the other entities I've identified who would like to work cooperatively to develop a regional project. I believe that the contract we've submitted satisfies the requirement of Special Condition 8 that we present the district with a contract for an unspecified period, but for the full 12,000 acre foot before the 5th year anniversary of the permits. As you are aware, our permits have, I think there are either 2 or 3 of the permits have a 5th year anniversary of tomorrow, and the remainder of them, their 5th year anniversary is January 26th. So I believe we have satisfied the requirement to maintain the permits as originally granted to Gatehouse and renewed on January 11th by letter provided by the general manager under section 361145 of the Texas Water Code, mandating automatic renewal of permits, not seeking amendments. Since and after the receipt of the renewal letter, I filed the application for a no volume increase amendment to modify Special Condition 8. We presented to the district 2 alternatives in that amendment. One was to extend the time date in Section 8, the 5th anniversary, to a date certain, January 31st of the year 2025, approximately 4 years from now. The idea behind that alternative was to give Gatehouse, which acquired the property in January of 2020, a full 5-year term in which it could accomplish what Forestar elected not to even attempt to do based on corporate internal decisions, and allow us to pursue a contract. At the same time, Gatehouse was pursuing contracts, and as I stated a few minutes ago, secured a contract with Central Texas Water Supply. On that basis, and my belief that it satisfies the current requirements of Special Condition 8, I don't think it's necessary to consider alternative 1 in the amendment. However, I think it's beneficial for the district to consider and grant the amendment we've requested with 2 thoughts in mind. First is alternative 2 presented language which is similar to the language in the recharge permit, which basically requires that the permittee provide the district with notice of contracts it enters into and keeps the district apprised of who, where, when, why, and how it's using the water, so that the district can ensure its ability to properly monitor, supervise, and review the production under that permit. I would urge the board to grant our amendment using alternative 2. While we have a contract, which we have presented, Gatehouse intends to work fully cooperatively with the district and would be pleased to present future contracts or contract amendments to keep the district apprised of Gatehouse activities and how and where it is beneficially using the water it's been granted the privilege to produce. So with that said, again, I would urge you to grant the amendment. The second point, using alternative 2. The second point that was associated with the amendment application I presented was the presentation of a modified or amended, or what I described as the 2021 Monitor Well Construction and Maintenance Agreement. This was a revised draft of the 2016 agreement that was negotiated and entered into between 4-Star and the district. And this particular contract targets and tries to answer the questions that the board has asked, in particular the many questions Mr. Phil Cook asked of me during the December board meeting and expressed concerns about in the November board meeting. And it clarifies some of the language. It makes clear the requirements with respect to the obligations under the Monitor Well agreement. Now, I will tell you that just like the other Monitor Well agreements the district's entered into with Recharge, the final locations of wells and the formations in which they will be constructed and completed are not set forth in this agreement. And there's a reason for that. The reason goes back to why it wasn't in the original 4-Star agreement. The idea when we reached that agreement in end of 2015, early 2016 with the district on behalf of 4-Star was to have the experts, not the lawyers, not the policymakers, but the hydrogeologist and the management, your general manager, Andy Donnelly, your hydrogeologist, 4-Star's hydrogeologist, Mike Thornhill, who is still the Gatehouse hydrogeologist, to sit down and look at what the needs, desires, for monitoring were and the best and most efficient and effective places to put those wells. Now, I'm glad we didn't do that and didn't specify that we did what we did, and we didn't specify well locations in 2015, 2016, because at that time, all emphasis was on the Simsboro Aquifer exclusively. We would not have had the opportunity we have now, and which is provided for in what I'm calling the 2021 Monitor Well Agreement, to actually vary the location of the wells by using aquifers other than the Simsboro that are of high interest to the district board members, and to drill wells in formations that are believed to be communicating with the Simsboro, and facilitate the opportunity for the district to get real-time data that will allow them to measure and either verify and confirm or to the contrary, prove it's not communicating based upon production out of the Gatehouse project. So I would ask you in summary to do 2 things. One, to grant the request for the automatic renewal of the transport permits. I would recommend you sync them up with the 5-year renewal of the operating permits. That way we have one date that we look at, and as Gatehouse continues to comply with the district's rules and its permits, every 5 years, the district will be in a position to automatically renew those permits and we can go forward. Secondly, I would ask you to grant the requested amendment for no increase in volume by modifying existing Special Condition 8 to adopt the language of Special Condition 8 Alternative 2 in the application we filed. And with that, I'd be happy to answer any questions that the board might have.
Before we open up to board questions, just for the record, this is a small world, I guess. But while I was city manager for the city of Lampasas, I did serve several years on the Central Texas Water Supply Board of Directors. But when I left the city of Lampasas, It's been 15 years now. I have had no discussions with any board members or any officials of the Central Texas Water Supply System, but I want the board to be fully aware that in my previous background, I was a director at the Central Texas Water Supply Corporation. With that, I'll open it up to questions from the board.
I have one question, Carl Steinbach. You said right-of-way work was started just on property where the wells are located. Would you clarify that for me?
Yes, sir. Mr. Brown, using his earth moving equipment, has begun clearing the right of way from well number 5 to his property line to access the public rights of way that we would then join and continue the conveyancing system. In the information I provided to Mr. Totten and Ms. Martin, there are plats that reflect all of the gatehouse leases and authorized well locations, and a specific plat for Mr. Brown's tract, which includes well number 5 and the monitor well. And they're all, and the multiple photographs that I referenced.
Thank you.
Yes, sir.
Okay. Any other directors have questions?
This is Phil Cook. Mr. McCarthy.
I have one.
Okay, I'll get
Would you
next,
explain to us what a no increase in volume request is? What does that term mean?
Thank you, Mr. Cook. The current permit authorizes production of up to 28,500 acre feet of water per year from 10 authorized wells. The permit has conditions, however, that start out and phase in, and this is something that Four Star brought to the district in 2015, and Gatehouse has continued. Phases in the production, starting out at a 12,000 acre foot per year authorization. And then over time, we have to pump that amount or a 2/3 of that amount for a specified period of time and then present data to the district. Mr. Totten has a formula he developed and he can explain it better than I can. He's smarter than I am and I've never understood the equations, but something that he developed with Mr. Donnelly and Mr. Thornhill commenting on it, that demonstrate we're not having an adverse impact on the aquifer, and then move to the next phase of production under the 28.5, which is 20,000 acre feet of water. We produce that for a period of time, again, providing the data to the district, and we can then move to the 28,500 acre feet. So from the no increased volume perspective, we are not asking to increase the total volume above the 28,500 acre feet currently authorized under the permit.
Thank you. But I was just wondering if that term, no increase in volume, had a legal definition, or I just don't understand. I'm unclear on how it applies to special condition 8, but anyway, I was hoping there would be a clear answer to that. You know, maybe there's not, but I was just wondering about that specific term is all. I understand the terms of the contract pretty well.
Yeah. Yes, Mr. Cook, thank you. The term comes from the district's rules that we cited as the basis for the application. And my understanding, there's not a definition in the district's rules. My understanding is that if production is authorized at a specific volume, if you do not request more than the volume already authorized, you are not asking for an increase in the volume. I think we're using the rule of construction.
Tasha, is that your?
Yeah, Director Cook, I was just going to explain that it basically initiates from Rule 5.7, I believe. And when you're not asking to increase the rate of withdrawal or the full authorized production amount, you can come in through an amendment that would not be subject to a public hearing, contrary to an increase amendment that would be subject to a public hearing.
Thank you. That does clarify it somewhat, although I'm not the sharpest knife in the drawer about this stuff.
Mr. Sherrill, you wanted to add a question?
I do, sir.
Go ahead. Take it away.
The last paragraph, thank you, sir. The last paragraph talks about blending of water from other sources. What does that mean?
I'm sorry, Mr. Sherrill, the last paragraph of which document?
It's, hang on a second. It's the second page. It's not the first, it's not the last.
I think I
It's
can.
from a memorandum that we've gotten.
Okay. I think what
Go
that,
ahead.
I think what that's referring to, Billy, currently Central Texas Water Supply gets their water from a reservoir, Stillhouse Reservoir, and that's called surface water. The water they would be getting,
Yes, sir.
so the water they would be getting from Gatehouse is groundwater, and you do have to analyze when you combine surface water with groundwater. Sometimes you may have to chemically treat it to make it blend to meet the requirements for drinking water and things of that nature.
Okay.
Does that help?
Well, yes, sir, but do you lose water because of evaporation, groundwater from evaporation when you put it in a reservoir?
I don't know how they're going to use it, but certainly you do lose some water if in a reservoir, in the summertime, but I don't know how they're going to blend it and how they're going to use it to say whether or not the groundwater would be, I mean, they're engineers here. I'd rather have him answer that question because I don't know. I was just trying to explain that you've got to take into account you have two different types of water and they have to be treated appropriately to blend.
President Talbot, this is Steve Coleman. May I help with that?
Sure, Steve, go right ahead. Good to see you.
Hey, Mike, good to see you. It's been a while.
It has been.
Yes, the water from the Simsboro Carrizo is pristine, as y'all know. And the water treated by Central Texas is very good drinking water quality that satisfies the TCEQ potable water requirements. And both sources would be blended together to produce even a better water quality. So there'd be no evaporation. It would all be done in a water storage tank and then delivered to the users. Thank you.
Thanks.
So thank you. Take that fella and put him back up on my screen, please.
Yes. Steve, can we put Steve back up on there?
Would you please ask? I want to ask that man another.
Yes.
Please.
It's this is on speaker view, so if Steve is speaking, he'll appear on your screen.
Okay.
Otherwise, I can't control who's on anyone's screen.
There he is. All right. I want to ask him. You said that it's going to be put in a tank, and you're going to blend it inside the tank. Is that correct, sir?
Yes, sir. And that
So
conforms.
you're not going to put it on out in the.
Well, y'all's water is so good it can go directly to customers, but at a point where it meets Central Texas's existing distribution system, the likelihood, and the way I design systems, I've been doing it for 50 years. You put it in a ground storage tank, you blend it, you make TCEQ happy with all of the constituent requirements due to corrosivity, disinfectants, contact time, etc., before you deliver it to customers, so that the water is potable, disinfected, and meets their requirements. So I see no issues of any use of this water, whether it goes to direct customers of Central Texas or whether it's blended and then delivered to Central Texas customers.
Okay, I'll try it one more time. Both types of water will be put in a above ground storage tank and be blended and pumped out through the distribution lines to wherever it wants to go. Correct?
That is one scenario. The other scenario is that we go into a ground
Say that
storage
again, sir,
tank.
please.
Yeah, can y'all hear me?
Mm-hmm.
Okay. Yeah, that's one scenario. The other scenario is that as
About
we,
every fifth.
I can't hear you.
Think we're having,
I hear about every fifth word.
Oh, no. Well, let me see if I can turn my volume up. I live out
Mr.
there.
Tallman,
I live out there. I live out there.
Cheryl
Like,
that I'm having trouble with.
are y'all having trouble hearing me?
No, Steve. I
Not
think
you, I'm having trouble with Mr. Cheryl.
Yeah, I think the problem is Mr. Sherrill's connection. I'm only hearing about every third or fourth word from Mr. Sherrill.
And that's my problem with y'all. I only hear just every so many words.
Understand.
Okay, you said something about putting in an underground
No.
storage tank.
No,
Am I
sir. No,
hearing
sir.
that right?
No, sir. Can you hear me
Okay.
now? Can you hear me?
Okay. Okay.
Okay.
I hear.
No,
I hear every fifth word.
Okay, a typical water distribution system delivers water to a ground storage tank over a long distance, and then you repump that for pressurization purposes into elevated storage tanks. And then the pumps operate off the level in the elevated storage to properly provide pressure and volume to the customers. Did you hear that?
Okay, yes, sir, I did. Thank you very much. Appreciate your assistance.
Oh, happy to.
does anyone else have any questions?
Yeah.
This is,
Go ahead, Larry.
go ahead, Larry.
Okay. Just want to make sure. So it would never, the water would never be put into a open reservoir, pumped in it just to have, and then to be mixed. You would be directly into your.
Okay,
Go ahead.
This is Steve. That is correct. That is correct.
Okay.
Okay. Mr. Cook, you had another question?
Not a question, just a comment to Mr. McCarthy. I appreciate you responding to my questions from the December meeting, but I haven't received them. So I'm not trying to be obtuse. I'm just don't know, what your replies to my questions were. I don't mean to make a big deal of it. I just want that to be a note.
Thank you, Mr. Cook. I appreciate that. And let me be clear, I didn't have a transcription of your questions. I took notes on your questions and tried to address your questions in the rewrite of the Monitor Well Agreement draft, the 2021 Monitor Well Agreement that I submitted to the district. I tried to answer them in there, whether they were questions or concerns. We tried to have them addressed how we would operate under the Monitor Well Agreement. I think Ms. Martin and Mr. Totten are in a better position to address some of your questions, possibly offline, but that's where it was. I didn't actually have a question answer transcript that I provided. I had tried to take a lot of notes of what yours and other director comments were, and have been since last spring when the whole issue of Monitor Well system for the district came up. And I've been in contact with Ms. Martin and Mr. Totten about that issue. We've had, along with some of the managers of Gatehouse, we've had discussions with them about Monitor Wells in an effort to develop this 2021 Monitor Well Agreement. I think it does address your questions. I'll let you consult with your attorney and general manager to get their take on it, though. But that's what I did. I didn't actually have a list of question answers, to be clear.
I think I have seen of our council's comments about that. I probably just didn't recognize them, for what they were as, coming from you.
Okay. Does any of the other board members have any questions of Mr. McCarty or Mr. Coleman?
Yes, Herbert Cook.
Yes, go ahead, Mr. Cook.
I have 2 or 3 questions. The first question is right away that Gary Brown is clearing. How many hundreds of feet or thousands of feet is he clearing to the county road or Highway 77?
I'm a lawyer and I can't answer that question. Mr. Cook, and I'm not being flippant with you. The affidavits and declaration we presented to you provide evidence of that. And again, we were looking at the statutory language, which reads only commencement of construction. There's no specification, so we didn't get out there and measure it. When you get a chance, when Mr. Totten and Ms. Martin are able to provide you with copies of the affidavit and direct declaration, you'll be able to see the photographs and some expansive areas that have been cleared by Mr. Brown. Again, there's no, you have to do a half mile or a mile or anything like that in the statute. It's merely the commencement. And so that's what we were trying to document, that we had commenced.
Ed, may I say something? May I say something
there.
to that? May I say something, Mr. Cook and Ed, on that?
Yes.
Steve Coleman. A water system to transport water, I guess definition wise or whatever, but whether it's a surface water supply or a groundwater supply, you have a starting point. With a surface water supply, you have to have your intake system, your pumps, your controls in the lake, your pipeline system to the treatment plant, into storage, and then it is pumped, repressurized to pump to the community that you're serving. In a groundwater system, instead of having the raw water pump system in the lake, you've got a pump and a well. And part of the definition of transporting water would be you have to drill your well first and complete it, of which 4-Star/Gatehouse has done that already on 3 wells several years ago. And so now the task is to take those wells that are completed, to flush them out, clean them out, put some permanent pumps in them, pump it to a ground storage tank nearby, do your disinfection, put your high service pump station in, and then pump it through your transmission line to your demand center where you're going to deliver water. So a portion of the transport system has been installed, and that now we're ready to move forward with delivering water to the customers. So.
And how far are you going to have to go with this to the demand point to tie in?
The delivery point and the Central Texas conceptual engineering drawings was, I believe, about 35 miles or so.
Okay, thank you about that. And then my last question, y'all made the comment that y'all have a security contract. Have you already secured a price for delivery of this water?
For the year 2021, yes, sir. We sold the water in place to the Central Texas Water Supply for $1.
So y'all haven't laid a foot of pipe or done anything, and Okay, I appreciate everything. Thank you.
Mr. Cook, if I could clarify, the project has investments of in excess of $7 million in hardware in the ground on the leases, and hundreds of thousands of dollars in engineering and hydrogeologic work in support of the project. Substantial
Exactly.
investments have been made.
Exactly, but you haven't laid 1 foot of pipe to get to that delivery point yet, or secured easements or right-of-ways?
We have easements and right-of-ways. Yes, sir, we do have those. We don't have them all, but we do have them. And there is no requirement at this point in time to have actually laid pipe.
Okay, I understand that. I'm just trying to get an idea of how much cost y'all have involved in your project and that type of thing. But you're answering my questions.
All your questions answered, Mr. Cook?
Yes, sir. Yes, sir.
Great.
Thank you.
Good. Does any of the other board members have questions?
Mike,
I have a question, Mike.
Mike Semaine first, and then Kay, I guess. Mike, go ahead.
The payment made is $1. $1 for what?
For the right to control the water authorized by the permit, Mr. Semang. And if you think about fair market value of the water in the ground, given that the contract requires full compliance with the district permits and including the monitor well agreement, that's a fair value.
But
it ties up the water for the Central Texas Water Supply Corporation to truly get into, study, evaluate, figure out how they would use it, where they would use it, go and solicit and get contracts with their customer base for the delivery of that water long-term. In the meantime, they will review all of the engineering work that Mr. Coleman has done for the delivery point that he was describing some 35 miles away, and we'll begin laying that conveyancing system in the ground, as well as developing the monitor well system.
But that is $1 green bill. It was the total consideration. Is that correct?
Yes, sir. Cash paid in hand.
Okay. Thank you.
Just to follow up on Mr. Semaine's question, you say that it's 35 miles approximately conveyance from the wells to Central Texas. You must have at least some idea how much easements you have and how much more you're going to need, because 35 miles is a fairly long distance that you're going to have to get right-of-ways and such for. So are you 50% complete, 60% complete, 20%?
I don't have that information available to me tonight, Mr. Talbot. As I explained in the prior board meeting, we have our easements and right-of-way authorizations from our landowners.
While you're here.
And we also have the ability to use the public rights of way for the project.
May I say something, Ed and Mike?
Yes, sir.
We just completed this is Steve. We just completed a 22-mile pipeline project to serve the Gerald area, and the Lone Star Regional Water Authority was my client, and we designed the system. From the time that we applied for financing to the Texas Water Development Board and acquired all of our easements for 100 property owners, and ran that pipeline and the 2 pump stations, 2 ground storage tanks, and 1 elevated storage tank for a cost of $30 million. It took 5 years to do that project. So you start on day one and you have your water source, which we have, our groundwater. It takes time to get all of that done. There was probably 2.5 years in getting design and easements and 2.5 years of construction. So that's what you're looking at in a 20, 30, 40 mile pipeline project. So, you know, we've taken baby steps so far, but we can't take more steps unless we know we've got our permits. And so when we know we have that, then yes, we will then move forward and meet all the requirements of the board and all their monitoring well requirements and create a very needed public water system. That's all I have.
Kay, you had a question?
Yeah, I was just wondering when Gatehouse bought this project and they did their due diligence, what were they thinking about that special condition number 8?
I'm sorry, Ms. Rogers, I can't answer that question. I can't tell you what the minds of the principals of Gatehouse as part of the negotiation.
Okay. Okay. And on that contract for $1, what, I mean, or do they have any duties under that? I mean, do you consider that valuable consideration for a contract?
Yes, ma'am, we do. Under Texas law, a contract is found to be binding and legitimate if there's an offer and acceptance and consideration that's paid. It doesn't specify how much that consideration is. And again, as I said earlier, when you look at fair market value and what is entailed, Central Texas is going to be looking at water, studying it, doing a lot of things on their side of the delivery zone, looking at their customers, getting that lined up. We're going to continue to do more of what we've already been doing with expensive engineering and actually construction and commencement of the monitor well system that the district is interested in seeing us construct, as well as our conveyancing system. And
So are
during
they going to turn for all of their work to you, their work product? I mean, is that additional consideration? I'm just confused about this $1.
I think, Ed, may I say something?
Yes, sir.
And Mike, I think Lee Kelly's on the line. He's general manager of Central Texas Water Supply Corporation. He's been in the water operations and treatment and management business for 45 years, probably. I've been in it 50. Sorry, Lee, if I've aged you, but I'd like Lee to come on and explain the planning that he's done for using his existing water supplies and future water supplies, particularly this supply that could benefit the citizens of Williamson, northern Williamson County. So would that be permissible to listen to him?
He can give a brief overview, yes, just we'll be cognizant of our time.
Yes, this is Lee Kelly, General Manager of Central Texas Water Supply. Some of y'all may know or may not know, all the BRA water is sold out of Lake Stillhouse that we have mainly operated out of for 40 years. And we are looking and have need of water that is compatible with surface water. And this water is very compatible, and we're very interested in this and going ahead with a project and delivering this to our customers in Williamson County. That's all I have. If you have any questions.
Thank you, Lee. Does anyone else have any questions?
I have one quick question.
Go ahead, David.
To the General Manager of Central Texas Water Supply Corporation, what you said was made sense. You said you're very interested in this water. Does that mean that you have committed in a binding contract to purchase and use this water?
We're working on that.
So you have not executed, I'm sorry, you have not executed a binding contract with Gatehouse to purchase this water. You've only tied the water up. Is that correct?
Now, Mr. Fleming, this said McCarthy, they have signed a contract. They have purchased the water for the year 2021. It's committed to them. We cannot sell it to anyone else or use it.
What happens after 2021?
They, as part of the contract, they also paid an additional consideration for an option to negotiate a longer term contract. We'll be visiting with them about that during 2021, as well as joining them and visiting with the other three entities we described to you, BRA, City of Round Rock, and City of Georgetown.
So that may or may not happen in the long term after 2021.
That we don't know what will happen
Right.
for 2022 and thereunder. My presentation to you and my comment was that we've complied with the requirement in our permit to present you with a binding contract. The permit did not require a term of years beyond a year. It did not require actual delivery of the water. It required a contract for the water, and we have presented a contract for the water.
Yeah, don't put words in my mouth. I'm just trying to get clear.
No, I'm sorry. I was trying to answer your question.
No, That's okay. You've answered my question. Thank you.
Thank you.
And Director Fleming, I just want to add that we received the contract, shortly before the meeting, around 5:30. And so, as you can imagine, that's not enough time for review. So we'll be reviewing that and also looking at the demonstrations provided related to the right-of-way clearance. And so, that's why this may be coming as a surprise to the board, because we haven't had a chance to send it to y'all.
Oh, and obviously, my final question is going to be to staff and to you, is this considered what you consider a binding contract? And what you're telling me is that you're not ready to tell me that yet. Is that correct?
That's correct. I mean, it needs to be reviewed, but.
So how are we going to
take action?
So special condition 8 actually doesn't call for any board action in the permit. So the permit condition 8 simply says the binding contract deadline and that it needs to be submitted. So, we're not asking for the board to make a determination on the validity of the contract tonight.
But isn't special condition 8 based on whether that is a valid binding contract or not?
Right. The lawyers are going to look at that.
But we can't, how do we take action tonight if y'all haven't got a recommendation?
Right. That's what I've been struggling with.
Well, so we're going to review it and determine if it is compliant, if that contract constitutes compliance with special condition number 8.
But I reiterate what David, I think David's making a good point. How can we make a decision tonight without you having the time to review that and recommend to the board that it meets the requirements and satisfies requirements, and deal with the other issues of the expiration dates coming up? I just see a juggling act of several different things floating in the air here. And I just want to we make a good decision so that we're fair to the applicant, but also we don't put the district in a bad position because we haven't had time to evaluate and see what the contract says and some of the other things that Mr. McCarthy has represented to us tonight.
And my point is if we take a vote on this item and we vote to renew the operating permits based on the fact that Mr. McCarthy says they have a binding contract, and then you come back to me and say, hey, this isn't a binding contract, then we can't do that until we have your opinion of whether it meets the requirements of special condition 8.
So, Director Fleming, let me clarify, and this might be, another misconception for other board members, but the renewal that's at issue today and that we're posted for today is for the transport permits. The operating permits have already been renewed pursuant to the statute and the rule. That happens automatically. So
correct.
The operating permits is not an issue. The renewal of the transport permits is an issue on the agenda, which special condition 8 is not one of the factors that you would consider
in the transport permit. But there is a very important factor in the operating permits. Wouldn't you agree?
I agree, but that the renewal of those permits is not on the agenda. The third piece of this, so you've got a contract that was just submitted. You're posted for the renewal of a transport permit. The third piece is that the board has been asked to consider an amendment to special condition number 8. My recommendation would be to table consideration of that amendment until we can review the contract.
Okay.
Thank you.
Yeah.
Thank you. We can go in executive session anytime you're ready, as far as I'm concerned.
Natasha, if we were to postpone the transport permit or to approve it and deal with special condition 8 at a later time, is that still a viable option for us, or because, or do we need to do that, deal with special condition 8 one way or the other tonight? I understand your predicament and not being able to evaluate the permit. And you're in a kind of a catch 22 on this. But I'm just wondering if we don't, what happens to special condition 8? If we don't act on it tonight, does it automatically go into effect? Or because we haven't evaluated the viability of their transport permit and their contracts, if we don't act on special condition 8 tonight, does it go away? Is it no longer an option for us? Or do we need to, anyway, I realize that special condition 8 is automatic, but it's contingent upon having the binding contracts.
Well, I'm sure that we all have those types of thoughts, and I think those will be best covered when we adjourn into executive session to consult with our attorney.
Agree.
Mr. Talbot, if I could try and clarify one point, please, before you go into executive session.
Mm-hmm.
Special condition 8 is in the operating permits. It is not in the transport permit. It has nothing to do with the transport permit. The transport permit, because the district issues those separately from the operating permits, is an entirely separate consideration. And the board has the information it needs with respect to the transport permit, I believe, to be able to act upon that tonight. With respect to special condition 8, we believe that we have complied and satisfied with its requirement, but we also have pending before you an application to amend operating permits to modify special condition 8, either to grant an extension of the period of time in which to present you a contract, because at the time we filed that application, we didn't have this contract. We were still negotiating it. Or in the alternative, to adopt the language that is the language as a special condition in the recharge permit that the district issued, that provides that not that there's a date certain by which a contract must be obtained, but that prior to delivering water under a contract, a copy of the contract be presented to the district. That's alternative 2 in our amendment. And that's the alternative I would ask you to grant. We're not trying to, now that we have a contract, just say condition 8 has gone away because we had a contract. We are saying that it has been satisfied because we have a contract, but we're asking for inclusion of a permit that maintains the district's ability to be supervisory in its role of our use of the water, and that any contract or any amendment or new contract we add, we present to the district so the district is knowledgeable about it and is able to monitor and supervise it.
Okay. Before we go into executive session, has anyone signed up to address the board on this item?
Yes, sir.
Mr. Weir, go ahead.
Okay. Thank you, Mr. President, board members. Andy Weir, member of Bastrop County. What I would speak to is the gatehouse permit, operating permit, special condition number 8. So depending on the validity of this contract that your council will be reviewing, the permits will either lock in at 0 acre feet per year if the contract is not valid, or they will lock in at 12,000, correct me on the exact number, 12,000, the number that's stated in special condition 8, you have to present the contract by the 5th anniversary, that's tomorrow, for the 12,500 feet of water. So then you lock in at that amount. That's the maximum you're going to get because it took you 5 years to get at least that amount. So they have done that if this contract is valid. If you accept either of the amended section special condition 8, you open them to come back for additional groundwater over and above what the current special condition 8 locks the contract into. So then it does become an increase amendment, and it would require going to a full board hearing, etc., that whole public review process. So you do not take any action on special condition 8 because that would undo yourself. You would put yourself at jeopardy for increases in the amount. The reason that's important, the 4-star wells are located right smack in the middle of the wells that I showed you today. All those wells in Lee County where people are suffering and spending thousands of dollars, that's the well field for Gatehouse. And so you're adding insult to injury to those Lee County residents. On the transport permits, you do need to scrutinize that carefully. You have the affidavits, you have the land clearing. It's a noble effort on the part of Gatehouse to show this beginning of the conveyance system. But surface land and the engineering process is not necessarily, does not seem to symbolize a conveyance system. And I think I heard that from several of the board members. So my emphasis would be, you do need to validate whether this is a binding contract. Do not move on special condition 8 because you open yourself up to an increased permit amendment. And to, at this time, only approve the transport permits for the alignment with the operating permit, which I believe that was renewed for 5 years. So do not exceed that. Thank you.
You bet. Is there anyone else that has signed up to address the board on this item? Does the board have any more questions?
Mr. Talbot, Ed McCarthy, if I might, I don't want my silence to leave the board with any misunderstandings or misimpressions. I would like to correct one point Mr. Ware made. If we have satisfied, as we believe, the requirements of special condition 8, then the permit is locked in for the full 28,500 acre feet, not 12,000 acre feet. I just wanted to be clear as to what that special condition said. I didn't want you to think that all we had was a permit for 12,000 acre feet, and when we operated under one for 28.5 that we had misled you. So I just wanted to clarify that point.
Thank you.
President Talbot, I agree with that reading of special condition 8.
Okay, that's fine. Thank you. With that being said, it is now 9:41 p.m. And at this time, pursuant to the Texas Government Code Section 551.071, the board will adjourn into executive session to seek advice of its attorney regarding pending or contemplated litigation, including but not limited to the following. Items 11 and 12, as stated on tonight's agenda, consultation with attorney regarding the above posted gatehouse renewal and amendment permits requests. We will now adjourn into executive session. Natasha, I'll turn it over to you and Ms. Smith for any action that the board desires to take.
Well, I believe we need to reconvene.
Oh, yes, excuse me.
Session.
My apologies. The board will reconvene back into regular session at 10:43 p.m. And they have consulted with the attorney regarding items 11 and 12. And so you're back in regular session. And so I will turn it over to Natasha.
Well, and I guess I then will then in turn turn it over to our new Vice President Smith to preside over these two items. So Vice President Smith, if you want to call for us to consider item 11 and any motions to be considered under item 11.
Yeah. Okay. would anyone like to offer a motion on item number 11?
Ms. Vice President, I would like to offer a motion. I would like to make a motion to renew the transport permits as listed in agenda item number 11 in order to synchronize the expiration dates of the operating and the transport permits to January the 21st of 26 and January the 26th of 26, that being 2026.
And then call for.
Is there a second?
I second.
Who is the first one?
Phil Cook.
Who is the second? Phil Cook? Okay. Second from Phil Cook. And I don't have a list to go for. Can we just do, does
I can do that for
anyone
you.
oppose this action?
Well, I guess you want to call this.
Okay, go ahead.
Discussion first on the motion.
Oh. Is there any discussion? Any questions? If not,
I will call for a roll.
Director Talbot would.
Yes, I will do that.
Thank you.
Phil Cook.
I'm in favor. Yes.
Okay. David Fleming.
Yes.
Kay Rogers.
Yes.
Carl Steinbach. Carl. Okay, I'll jump
He's
down.
on.
Carl?
Carl's on mute.
Okay. Mike Semaine.
Yes.
Herbert Cook.
Yes, sir.
All right. Larry Shoddy. Larry.
Can't unmute.
Okay. Billy Sherrill. Okay.
Billy's on
Carl
mute.
Steinbach votes yes.
Okay.
This is
Carl,
Larry Chatty, and I vote yes.
the motion carries. I don't want to delay the meeting any longer until
Thank
Billy
you.
gets on. So move on to item 12.
Yes. Does anyone want to make the motion on item number 12?
Yes, Madam President or Vice President, I will, there will be two motions for this item. The first motion I'd like to make is to suspend special condition number 8 so that the permitted withdrawal will not be reduced until the validity of the submitted contract is evaluated.
Thank you. Is there a second?
I second the motion.
Okay. Any questions from the board?
Can you hear me?
Yes, I can.
Oh, that's the only question.
Okay. Phil Cook.
Yes.
David Fleming.
Yes.
Kay Rogers.
Yes.
Carl Steinbach.
Yes.
Michael Semaine.
Yes.
Herbert Cook.
Yes, sir.
Larry Shoddy.
Yes, sir.
And Billy Sherrill.
No.
Okay. Okay.
Madam Vice
Well, how many
President.
was that? What was?
It was 1,
Go ahead.
2, 3, 4, 5, 6, 7, 8 in favor and 1 no.
Thank you.
And I'd
Go
like to
ahead,
make
Mike
one,
Fleming.
I'd like to make one more motion, and that is a motion to table the permit amendment and the monitoring well agreement until a further meeting.
Okay. I don't think that needs a second.
It does.
Oh, it probably does need a second.
Yes.
Yes, I think so. Let's.
Oh, it does? Okay.
It's a separate motion. Yes.
Who
Who was
seconded
that?
it?
Samang, I'll second.
Thank you.
Okay. All right.
Thank you.
Any questions from the board? Phil Cook,
Yes.
David Fleming,
Yes, yes.
Kay Rogers,
Yes.
Carl Steinbach,
Yes.
Michael Semaine, he was in second, so that would be a
Yes.
yes. Herbert Cook,
Yes, sir.
Larry Shanti,
Yes.
and Billy Sherrill.
No.
Okay. Same again, Cheryl. 8 in favor,
Yes.
1 against.
Thank you, Mike. I appreciate your help since I was not expecting to do this
Well,
tonight.
I do a little cheat chart to keep track of that with these virtual meetings because it gets a little tricky. Okay, that will move us
Thank you.
down to item number 13, the general manager's report. Jim, it's been a long night. Could you maybe just condense your report? Because it's been a long meeting for the directors.
Absolutely. I'll be as brief as possible. One thing I do want to start with, and it was not directly listed, but this coming Friday will mark Peggy's 19th anniversary of working for the district. And I just felt like that was worth putting out there for some recognition. She's done a great job, and she's been here for quite some time with us. So,
well, just having to put up with me is quite a job.
So we've got basically 22 new wells registered with the district, 20 new ones, 2 pre-existing wells. The budget committee did meet earlier this month. Basically, we had 3 items of discussion on the agenda, looking at any changes that we might need to make to the budget, depending upon how the gatehouse permit gets sorted out. We discussed bringing on an assistant general manager, which we will, the budget committee will meet again to finalize some of those numbers and bring that back to the board in February. And then the third item of discussion, which we just had a very high level discussion of, was the possibility of setting up mitigation funds for impacted wells in North Lee County. That needs a lot more discussion. We're going to need to have a few more meetings before we're ready to bring any of that discussion to the full board for review. Additionally, the monitoring well committee did meet. We discussed working through some of the local drillers who have kind of boots on the ground with impacted well owners to get out and get good water level readings for them. Andy and I are looking to get out either late next week or early the first week in February to hit all of our normal monitoring wells in Lee County and also pick up as many of these new wells as we can. Third item that I have for you, the GMA 12 meeting did occur last week. And if you haven't yet, you will be receiving shortly a letter from the DFC committee from Post Oak Savannah. Post Oak Savannah had proposed making a change to the pumping file that would artificially have lowered pumping in the Carrizo below what's currently going on. This would have artificially increased the DFCs for both Brazos Valley and for Lost Pines. There were several other modifications they proposed that were all largely hypothetical changes. Those were approved by the GMA, but the GMA did not accept the artificially reduced pumping in the Carrizo. I'll set up a meeting with the DFC committee so we can talk through this further and kind of have a better position going into the next meeting, because I think Post Oak Savannah is going to bring this up again. But essentially what they were proposing would be like us creating a budget that didn't include rent for our building. You know, we know we're going to have to pay it, but if we don't include it, we can say we've got more money left over at the end of the year, but we're still going to have to pay that money. So like I said, that the GMA voted against making that reduction in the pumping files. And if you have questions about that, I'd be happy to address them further with you offline. As far as upcoming meetings, we have Region K, which is coming up January 27th, 10 a.m. That'll be a virtual meeting. And the next GMA 12 meeting is February 12th. So the week before our next board meeting.
Okay. Thank you, Jim. Natasha, did Greg Ellis ever sign on?
I do not see Greg
Okay.
listed, but I don't know that he had any items.
Right. So I will say there's nothing to discuss on 14. 15, you all know what to do on your conferences. Just get with the staff. If there's something you would like on the agenda or for future consideration, please let Jim or I know. And with that, I will adjourn tonight's meeting at 10:55.